In the meanwhile, you might remember a few weeks ago we talked with Lorinda Swain, whose alleged case of child molestation went on for 15 years, and we heard her perspective, and is often the case on the program. We try to get other perspectives, opposite perspectives as well. And joining us today is the Calhoun County Prosecutor, David Gilbert. Good morning, sir. Thank you very much for your time today. We appreciate your being here.
No problem.
So this thing went on for a long time. This kind of thing is fairly unusual, but this is the way the system is built, isn't it? When there are cases that might volley back and forth, there's a mechanism in place.
Well, in this case, the Court of Appeals and the Michigan Supreme Court were used quite a bit from 2002 until 2016. That's correct.
Yeah.
It's not unusual for people to file motions, and it's not unusual for people to file appeals.
Yeah, and they just, I would think, generally don't go on this long, do they?
They can. They can. There are cases out there. If you're in prison for long enough, you will be filing everything you can as often as you can.
Mm-hmm. So in this case, insofar as you can talk about it, the Supreme Court rendered its decision finally after all this volleying and all these years that went by that Ms. Swain was due another trial, and you decided not to pursue it. Why not?
Well, first of all, the issue from the Supreme Court had to do with what's called a Brady issue. A Brady issue was that the defense claimed that the detective in this case had interviewed somebody and that he didn't report that interview. That interview was actually with Ms. Swain's boyfriend.
Mm-hmm.
So this motion was brought after that detective had passed away. So there's really no way to rebut that.
Right.
The detective's passed. We've got people that could testify that they knew this detective. I knew this detective back in 2002. I've only been in office since 2012, but I knew him back in 2001, 2002, and he was a very good detective. That he had missed something like that is just beyond what I think he would do. But, you know, I respect the opinion of the Michigan Supreme Court. I don't have to agree with him, but I do respect him. Mm-hmm. And that's the reason for the trial, or the remand for a trial.
Mm-hmm. And because that person is no longer available, it would be difficult to go back.
But also, you remember, as she talked, her alleged victim has recanted.
Mm-hmm.
It's the second time the person's recanted.
Yeah. We'll talk more about that when we come back in just a minute. It's interesting because once this thing is rolling and then you have a recanting like that, it doesn't mean that this thing stops. It's, I don't know, like the forestall or something. It just keeps going.
It really depends, because in this case, it basically does stop the case now, because it's not just recanting. It's saying this, listen, I'm not going to testify to what I testified before. Therefore, we don't have a case, so we have to dismiss it.
We're talking with Calhoun County Prosecutor David Gilbert on WBCK. Back in just a moment on Friday morning. Hi. With us this half hour on Friday morning is the prosecutor in Calhoun County, David Gilbert. We've been talking a little bit about the Lorinda Swain case, which we've talked about in the previous weeks. So, let's talk about what generally happens then when you have a case and then the star witness says, no, it's not really true. I didn't mean this, and I was wrong, and I'm not going to testify. This turns the whole thing upside down, right?
It does many times. In this type of a case, it certainly does, because before you can actually bring in a lot of your evidence, you have to show that the crime was committed at first. And for this, you need actually, in this case, the alleged victim to testify. If that person doesn't testify, all your other evidence is useless. You can't bring it in. Right.
So how come then this thing didn't just stop? That is to say, this person then says, no, I wouldn't tell the truth. This really didn't happen. Why didn't it just stop and Lorinda released?
Well, actually, that case was dealt with, I want to say, in 2004. Mm-hmm. It's my understanding from reviewing the transcripts in this case, the person came in and testified that, yes, I did tell them it didn't happen. Well, why did you do that? Well, because they were giving me a hard time. And so I wanted them off my case, and I said it didn't happen. So within a few months of the conviction, he was with the same people, allegedly his maternal grandparents, and says it didn't happen again. And that's where it's been. It's my understanding, if I recall correctly, there was an appeal in 2004 based upon the recantation, and it was rejected by the higher courts.
Mm-hmm.
So the recantation issue has been over, as far as I know, since about 2004.
So, but the way you frame that, it sounds as though maybe there might have been some concern that the recanting wasn't genuine.
That was a big concern. I look at what my predecessors do. I'm the third prosecutor to look at this case, and I agree with what my predecessors have done. That's all I can really say. I agree with what they did, and I agree with the way the case was handled by my office, by me, and by my predecessors.
Mm-hmm. Let's talk about cases involving crimes against children. I mean, I asked this of the Innocence Clinic director, David Moran, who was with us a while back, who was integral in the reinvestigating of the Swain case. Is there added pressure when there's a crime alleged against a child to get a conviction?
No. There's no more added pressure than any other case. I know Dave, and I've spoken to him before, and I agree with a lot of the things that he says. I probably agree with a lot of things I say. But I don't believe there's added pressure. The prosecutor's job is to make sure that justice is done. Our job is not to make sure that there's a conviction at any cost. Our job is to make sure that people accused of crime are treated fairly. Mm-hmm. That way, you don't have to worry about cases being reversed in the Court of Appeals or the Supreme Court. Yeah. And when you talk about the Innocence Project and what they stand for, wrongful convictions, it's important to the prosecutor's office to make sure something like that doesn't happen. Police officers and prosecutors do not want to see innocent people in prison or in jail. Mm-hmm. And that's very, very important to us.
Moran's assertion is on a national level, there's somewhere around 10 or 11% of people in jail who are wrongfully convicted. That seems like a startling statistic.
I think he might be off a little bit.
Okay.
But we both agree that there are statistics showing that there are people in prison that were wrongfully convicted. And when you talk about wrongful conviction, you're talking about either police or prosecutors who are basically have set aside their oaths. But then sometimes you also have witnesses that lie. Mm-hmm. But in most cases, you've got testimony that actually is backed up by other sources.
How can you, as a prosecutor and essentially a law enforcement participant, try and uncover when a person is not telling the truth? I mean, how can you do that? As you said, some might elect to consciously set aside the oath and lie. How do you deal with that?
If I find out someone's lying, I'll do the best I can to prosecute them.
Mm-hmm.
It's something that law enforcement and prosecutors, and this is our system of justice. And if you go back, the old saying, well, it's better that 1,000 people go free than one innocent person go to prison.
Mm-hmm.
And it's better than 1 million people go free than one innocent person go to prison.
Right.
But it's something we combat all the time. What do we look for? We look for inconsistencies. And most of the time, an investigating officer will find those inconsistencies.
We're talking with the Calhoun County Prosecutor, David Gilbert. We'll take a short break and come back in just a minute on WBCK 8. Friday, we're here with the prosecutor in Calhoun County, David Gilbert. So one of the things that Ms. Swain said when we talked to her was, over the years, I didn't meet with prosecutors. Nobody came and talked to me from the prosecutor's office. Is that typical? I mean, how do you handle cases in general? Is it customary for you to want to interview the defendant?
No, it's not customary at all. We don't interview defendants. Police officers interview defendants. We interview defendants. We become witnesses. So, no. They have attorneys. We're not supposed to be talking to the defense witnesses, or not the witnesses, but the defendants.
Yeah.
We're not supposed to be talking to defendants. Sometimes you'll have somebody say, well, please talk to my client. And no, I'm not going to talk to your client.
Mm-hmm.
I have no problem. I did talk to Ms. Swain after the case was over, but I did not talk to her while it was still pending.
Mm-hmm. She gave the impression that her innocence might have been easier, her professed innocence might have been easier seen or understood, or whatever the right word is, if that interaction had taken place. But your point is that doesn't happen.
Well, I don't think it would have changed anything. I know what the prosecutors thought about the case. I know what they were doing as far as their interviews and things like that, and there's nothing too much that you could really say that's going to change anybody's mind.
Mm-hmm. You know, I think there's a perception out there that if you can afford an expensive defense attorney, you're in a better position to win a case.
Yeah, I heard David say you get what you pay for. That's not true. One of the things they did in this case was they claimed ineffective assistance of counsel, not just on the trial attorney, but on the first appellate attorney. And both of those attorneys were retained. So it's kind of like we've got very good court-appointed attorneys. They are underpaid. He also made the comment that they don't have proper resources. I agree that in some courts you have to fight for those resources, but I've got a friend named Kenneth from Bay City or Saginaw who actually brought the motion in the Court of Appeals. He appealed a ruling of a judge that didn't allow him to get the proper funding to hire an expert witness. Now the law is courts must supply the money for those experts.
Mm-hmm.
So you're not going to be deprived an expert just because you have a court-appointed attorney.
You know, these are difficult cases, I presume, if we use the Swain case as an example, where you have an assertion made that a crime has taken place, a counter assertion from the person accused that they are innocent, and no real evidence to show that it did or did not happen. This is tough.
Actually, there is other evidence, okay? And that's why, that's why you have prosecution. You've got one witness. Yeah, we can rely on one witness for a conviction. If a jury believes one witness beyond a reasonable doubt, they can find somebody guilty. But in this case, we don't have just one witness. But the other evidence, the other witnesses, basically require somebody to come forward and testify.
Mm-hmm.
So it wasn't. This was not a one-witness case. If you actually review the record, there are a lot of witnesses that testified. But it wasn't a one-witness case.
Well, and I guess I'm thinking about, for example, DNA or something. I mean, if you had something like that, there would probably been a conviction, and she'd be in jail today, wouldn't you?
The case would. If the court did what it did, I don't think it would have mattered if there was DNA. The Brady violation was not for not supplying evidence, okay, for not supplying the name of a witness.
Mm-hmm.
And the argument from the prosecution was, well, they already had the name of that witness. It was her boyfriend. How could we possibly be able to supply this, and how could we possibly know that this person claimed they were interviewed? They didn't come forward until after the detective had died. He died in 2010. They didn't come forward until, they didn't bring the motion or the appeal until 2011. This case was over in 2002. At what point didn't they know if it actually occurred? And to date, people that know this detective, there's no way he would have missed that.
So here we are now. It's done. It's over. Do you feel that a guilty person got away?
I'm not going to comment on that. I agree with what the jury did, and I agree that 12 people found her guilty beyond a reasonable doubt.
Yeah.
And I believe my office did its job.
All right. We'll leave it there. We appreciate the time you've given us today, and there are other legal issues someday we can talk about. We'll look forward to that.
Feel free.
Calhoun County Prosecutor David Gilbert with us on WBCK.